begin by saying I think in physics things are irreconcilable. I think in law very little is irreconcilable. These things can be worked out, although there clearly is in this area a lot of potential for conflict. As a non-lawyer, I should say up front, and also not as an advocate for any particular outcome in this field, but someone who's trying to, our organization is trying to focus simply on WTO compatibility of the various options and making sure that obligations the United States takes on are that A, it can meet them, and B, that they're consistent with international rules. I think I can say, for the most part, the answer to your question is it depends. It depends on what is developed both in domestic law here, as well as what direction the international negotiations take. The research we've done suggests that there are, as things stand right now, plenty of opportunity for conflict. There are a lot of issues out there that are likely to be litigated in the WTO. I think it's 100% certainty that anything the United States does will be the subject of a WTO complaint at some point. Whether there's any merit to the complaint or not is different. Someone will complain, probably the Europeans, and it'll have to be litigated. So it makes sense for us to have that issue in mind as we proceed. At the same time, I think it's fair to say that we could go down the current road without changing anything as far as the WTO is concerned. They have a dispute resolution process in place. They have rules in place. Lamy has said from time to time that he thinks those can be appropriately applied in this context. And he's probably right. That kind of ignores the question of whether that's the best answer and also the most efficient answer. And nobody's ever accused the dispute resolution process and the appellate body of being efficient. And if you're trying to achieve an environmental outcome, consigning things to a process that will take years and will probably end up in a big argument anyway over compliance after all the litigating is done may not be the most efficient. We have tended to think that the advantage in this area goes to the early actors, that the countries, particularly the big ones that develop a system first, are most likely to be the ones that set the legal standards that ensue later on. We are also inclined to think, and Jake can probably comment on this better than I, that eventually the international an international group, I'll be agnostic on which one or how we configured, will grapple with this and develop its own rules. I think it's probably best for the United States to come out of the box with a system of its own and then argue vigorously within the international context that the rules ought to be ones that embody and co-opt whatever it is that we've adopted. All signs in the Congress are essentially that that's not going to happen, and the world will very much march on without us. In fact, I was struck. I was in India in November for World Economic Forum, doing this panel with a bunch of Europeans and with an audience of a bunch of Indians, and I was intrigued. We had all decided beforehand we weren't going to trash each other in public, so we didn't. But the view of the Indians didn't express a view, but the view of the Europeans and the others on the panel was that the U.S. debate over border measures was ironic because they thought the pace of U.S. movement was so slow that at the end of the day it was going to be the U.S. that was going to end up paying the tariffs from other people's border measures rather than us charging tariffs against other people that haven't moved. And I have to say the pace in the Congress suggests that there may be some truth to that. We have looked at all the various options, and I think we can probably get into details on that later rather than take up more time now. I think I would just say that the compatibility issue really does depend in very significant ways on the configuration of what is done. I think generally speaking, we would say that a tax approach has a number of advantages, certainly in WTO terms, over a cap-and-trade approach. But it is clearly, I think, possible to write a cap-and-trade program that is compliant with international rules. Andy will tell you that he's done so. Other people will tell you that he hasn't, and I will tell you that every time I get into a debate with him, I lose. So I'm not going to go very far down that road. But I think that the research suggests that there are more minefields for a cap-and-trade program, and we can talk about that later, than there would be for a tax program. There are also questions of which has more environmental merit, which I'll leave till later either. But I think I better stop now and turn it over to the next victim.